by Shri Jayakumar Patil, Senior Advocate, who's not a stranger to us. We'll start with an introduction by our President. Sir.
Friends, I am happy to introduce my friend Jayakumar S. Patil, born in year 1952 in Kolasirsi Taluk, Siddhapur district. He had his education in his native place, Kolasirsi High School and SV High School Siddhapur. Then got a degree in Dharwad in 1971 and became a lawyer in 1975. After getting law degree from JSS Sakri Law College in 1974, he stood second to the college. He joined Office of Justice Swami, who later became a High Court judge. Up to 1179 he continued with him, and after Justice Swami was elevated, he started his independent practice. The Jayakumar Patil is a veteran in Bar Council, being there from 1995 and was chairman for 2 years. He is also now designated as senior counsel in 2002. This is a short introduction of Jayakumar Patil, as many of the lawyers know him, who he is. Thank you.
Now I request Shri Jayakumar Patil to deliver the lecture.
President Shri B.V. Achar, my friends and colleagues D.L.N. Rao, Prasad, R.V.S. Naik, Madhu Naik, and all my friends and colleagues. Today's topic as such is scope of judicial review on cooperative matters. Of course, probably subject has been chosen because I continue to appear in these matters almost from 79 till date. Therefore, Prasad has chosen this as the subject. Of course, with regard to judicial review, the general concepts, limitations, every one of those things are in no way different even with regard to cooperative societies. Ultimately, the famous saying that the writ jurisdiction, judicial review is about the decision-making process and not on the decision remains a half-truth. If theoretically that is to be said, if that decision-making process is wrong, in every case there is no question of sending back for decision, etc., because the time gap or by the time again it is to be done, all things would be over. Therefore, after that, after finding something wrong with the decision-making process, what relief can be molded is something that is with the court. In every case, it is not necessary that matter is to be sent back. But with regard to this, with reference to cooperative society, I have tried to give some tips for my young friends here. The concept of judicial review, a power of the constitutional courts under Article 226 by the High Court, Article 32 and 136 by the Supreme Court. The concept of power of judicial review and its ambit remains the same as regards the general principles. In respect of cooperative societies, it is still more restricted, as very few categories of cooperative societies can be termed as state or other authorities within the scope of Article 12 of the Constitution. Similarly, very few of cooperative societies can be brought under the category of authority referred to in Article 226 of the Constitution. There is a slight change in the position of a cooperative society in view of the insertion of the word or cooperative societies in Article 19(1)(c) by the Constitution 97th Amendment with effect from 15/2/2012, along with the insertion of Article 43B in Part 4 of the Directive Principles. To understand the change brought about by making the right to form a cooperative society as a fundamental right under Article 19(1)(c), supported by Article 43B of the Constitution, one must refer to some judgments of the Supreme Court. In the case of State of UP versus COD Chicoy, 1997 3 SCC 681, the Supreme Court took the view in para 16 that there is no fundamental right to, under Article 19(1)(c), to become a member of cooperative society. Therefore, a person can become a member as provided under the relevant Cooperative Societies Act under the terms imposed by that statute. In effect, it is said, formation of a right to form an association of members. It was a decision prior to amendment. Then all that was in the Article 19(1)(c) was association of members. Definitely association of members would have included cooperative society also. Therefore, a person can be, in effect it is said, formation, right to form a cooperative society right to form an association of members is a fundamental right under 19(1)(c). But once such association gets itself registered under the relevant Cooperative Societies Act, it is bound by the provisions of that statute, and members individually have no such fundamental right. Thus it is settled law, I am quoting that para 16, thus it is settled law that no citizen has a fundamental right under Article 19(1)(c) to become a member of cooperative society. His right is governed by the provisions of the statute. So the right to become or to continue being a member of cooperative society is a statutory right. On fulfillment of the qualifications prescribed to become a member and for being a member of the society, and on admission he becomes a member. His being a member of the society is subject to operation of the Act, rules and the bylaws applicable from time to time. A member of the society has no independent right qua the society, and it is the society that is entitled to represent as a corporate aggregate. No individual member is entitled to assail the constitutionality of the provisions of the Act, rules or the bylaws, as he has his right under the Act, rules and bylaws, and is subject to the operation. The stream cannot rise higher than the source. In the case of Daman Singh and others, again it was held, once a society is registered under a statute, they are controlled by the statute, and so there can be no objection to statutory interference. It also held a member of cooperative society has no independent status, as cooperative society by itself is a corporate body. Therefore, individual members have no separate right. Para 9 and 11 I have quoted. In just what is being said in that decision is, individually the members are not recognized, they don't have a right at all. Once you have voluntarily got yourself registered under Cooperative Societies Act, nothing else remains. You permit the statutory interference. And in that decision, Constitution Bench judgment of Damayanti Narayan was quoted. And in a single sentence it was said, that was under a different context, it is not applicable. A judgment of the Constitution Bench was just referred and said it was under a different context, it is not applicable. So it happens in the Supreme Court. In fact, in the case of Damayanti Naranga versus Union of India, a constitution bench of the Supreme Court took a view that changing the constitution and composition of the society, which was registered under the Societies Registration Act under the name Hindi Sahitya Sammelana, UP legislature passed an act known as UP Sahitya Sammelana Act 1966, which enabled taking over management properties of Hindi Sahitya Sammelana, which was challenged. It was held that right to form an association guaranteed under Article 19(1)(c) cannot be confined to the initial stage of forming of an association. Para 6 of the judgment reads as follows. It was argued that the right guaranteed by Article 19(1)(c) is only to form an association, and consequently any regulation of the affairs of the association after it has been formed will not amount to breach of that right. It is true that it has been held by this court that after an association has been formed, the right under Article 19(1)(c) has been exercised by the members forming it. They have no right to claim that its activities must also be permitted to be carried on in the manner they desire. Those cases are, however, inapplicable to the present case. The Act does not merely regulate the administration and affairs of the society, but what it does is alter the composition of the society itself, as we have indicated above. The result of the change in composition is that members who voluntarily formed the association are now compelled to act in that association with other members who have been imposed as members by the Act and in whose admission to membership they had no say. Such alteration in the composition of the association itself clearly interferes with the right to continue to function as members of the association, which was voluntarily formed by the original founders. The right to form an association, in our opinion, necessarily implies that the persons forming the association have also the right to continue to be associated with only those whom they voluntarily admit in the association. Any law by which members are introduced in the voluntary association without any option being given to the members to keep them out, or any law which takes away the membership of those who have voluntarily joined it, will be a law violating the right to form an association. If we are to accept the submission that the right guaranteed under Article 19(1)(c) is confined to the initial stage of forming an association and does not protect the right to continue the association with the membership either chosen by the founders or regulated by the rules made by the association itself, the right would be meaningless, because as soon as an association is formed, a law may be passed interfering with its composition, so that the association formed may not be able to function at all. The right can be effective only if it is held to include within it the right to continue the association with its composition as voluntarily agreed upon by the persons joining the association. This aspect was recognized by this court, though not in plain words, in the case of OK Ghosh. The court in that case was considering the validity of Rule 4B of the Central Service Rules of 1955, which laid down that no government servant shall join or continue to be a member of any service association of government servants, which has not, within a period of 6 months from its formation, obtained the recognition of the government under the rules prescribed in that behalf, recognition in respect of which has been refused or withdrawn by the government. The court held it is not disputed that fundamental rights guaranteed under Article 19 can be claimed by government servants. Article 33, which confers power on the Parliament to modify the rights in their application to the armed forces, clearly brings out the fact that all citizens, including government servants, are entitled to claim the rights guaranteed under Article 19. Thus, the validity of the impugned rule has to be judged on the basis that the respondent and his co-employees are entitled to form associations or unions. It is clear that Rule 4b imposes a restriction on this right. It virtually compels a government servant to withdraw his membership of Service Association of Government Servant as soon as recognition accorded to the said association is withdrawn, or if after the association is formed, no recognition is accorded to it within 6 months. In other words, the right to form an association is conditioned by the existence of recognition of the said association by the government. If the association obtains the recognition and continues to enjoy it, government servants can become members of said association. If the association does not secure recognition from the government or recognition granted to it is withdrawn, government servants must cease to be the members of the said association. That is the plain effect of the impugned rule. In spite of the aforesaid Constitution Bench judgment, the Supreme Court in the Daman Singh case held that just because association is registered under the Cooperative Societies Act, therefore no further rights guaranteed under Article 19(1)(c) is available. It is under these circumstances, insertion of right to form a cooperative society of the nature referred to in Article 43b of the Constitution definitely makes a change. But that by itself will not in any way enlarge the scope of judicial review, except to the extent now the cooperative society or its members can challenge such of the commissions and omissions by the state in respect of rights of cooperative society and its members. The power of judicial review is extensively considered, more particularly with reference to contractual rights, tender, etc. In fact, the judgment in Tata Cellular, Michigan Rubber, and several other judgments are referred to and reaffirmed in a recent judgment in Subodh Kumar Rathore, 2024 SCC Online 1682. In para 55 of the said decision, it is quoted, thereafter this court in its decision in MP Power Management Company Jabalpur reported in so and so, exhaustively delineated the scope of judicial review of the courts in contractual disputes concerning public authorities. The aforesaid decision is in the following parts. Scope of judicial review in the matters of contractual disputes. The court held that earlier position of law that all rights against any action of the state in a non-statutory contract would be governed by the contract alone and thus not amenable to writ jurisdiction of the courts is no longer a good law in view of the subsequent rulings. Although writ jurisdiction is a public law remedy, yet a relief would still lie under it if it is sought against an arbitrary action or inaction of the state, even if they arise from a non-statutory contract. The relevant observations read as under. When offending party is the state, in other words, the contention is that the law in the field has witnessed an evolution, and what is more, a revolution of sorts, and a transforming change with a growing realization of the true ambit of Article 14 of the Constitution of India. The state, he points out, cannot play the Dr. Jekyll and Mr. Hyde game anymore. As nature is cast in stone in its character is inflexible, this is irrespective of the activity it indulges in. It will continue to be haunted by the mandate of Article 14 to act fairly. There has been a stunning expansion of the frontiers of the court's jurisdictions to strike at state action in matters arising out of contract based undoubtedly on the facts of each case. It remains open to the court to refuse to reject a case involving state action on the basis that the action per se is arbitrary. It is undoubtedly true that the writ jurisdiction is public law remedy, a matter which lies entirely within the private realm of the affairs of public body may not lend itself for being dealt with under the writ jurisdiction. In the said decision, court has further held that arbitrariness, procedural impropriety, etc., the principle laid down in Bareilly Development Authority case of a non-statutory contract, the rights are governed by the terms of the contract and the decisions which are purported to be followed, including Radhakrishna Agarwal, may not continue to hold good law in the light of what has been said in the ABL and followed in recent judgment in Sudhir Kumar Singh. The mere fact that the relief is sought under a contract which is not statutory will not entitle the respondent state in a case by itself to ward off the scrutiny of its action or inaction under the contract, and the complaining party is able to establish that the action inaction is per se arbitrary. Ultimately, court held that public law remedy remains a remedy open to the concerned party, of course subject to the limits of judicial review. A cooperative society may have undertaken running of a business, then relevant laws applicable to any other citizen with regard to carrying on that particular business will apply even to the cooperative society, where the cooperative society cannot claim any special rights on the ground that right to form an association is a fundamental right under Article 19(1)(c). For example, it may be seen, cooperative society might be running a bank. As regards its business of running the bank is concerned, it definitely is governed by Banking Regulation Act, which has nothing to do with the election of cooperative society, admission of members, etc. Like that, it might be running education institution. The law pertaining to education institutions or all those things, like any other, this thing would apply even to the institutions run by the cooperative society. But that itself will not mean that the right to form society as envisaged under 43B can be curtailed by that enactment of Banking Regulation Act or the Education Act. Such of the provisions which impose any condition with regard to the constitution, formation, etc., will have to be judged on their merit. It may be noted that invoking judicial review option against the cooperative society will not be maintainable unless the said cooperative society comes under the definition of the state or authorities as provided under Article 12 of the Constitution, and the said action involves public law element. Thus, in respect of action of cooperative society, let us say, in the field of education, health care, the power of judicial review is maintainable only in respect of such actions involving the public duties. It is so held in the case of St. Mary Education Society. Here, a correction might be required. In a recent judgment of about 6 months back, in Kushal Singh case, Supreme Court has opened an avenue saying a writ might lie against a person apart from habeas corpus cases, though they have not gone on to explain what they mean, but that's how it has opened an avenue. Now, coming to the ground reality, where thousands of writ petitions are filed by members of cooperative society or cooperative society by itself against the orders passed by the authorities under the Cooperative Societies Act or executive orders passed by the government and its officers is concerned, the matter is dealt with from a different angle, though not outside the power of judicial review. In such petitions, what is called in question is the action of the state and its authorities, which is contrary to the statutory provisions. In such cases, if a case is made out of violation of statutory provisions or violations of principles of natural justice or non-application of mind, arbitrariness, then the court would grant the relief depending on the facts, circumstances of the case. It is in these types of cases several other reasons for exercising the power of judicial review under Article 226, 227 of the Constitution have been laid down by the High Court and also by the Supreme Court. 1. Violation of principles of natural justice unless opportunity is specifically excluded by the statutes. Further, even if specific provision for compliance of natural justice is not provided in the statute, the same would be read into the statute so long as the order or the action by the state affects the rights of the parties. If the application of principles of natural justice is specifically excluded by the statute, then the court would even examine whether such exclusion is violative of fundamental rights. 2. Constitution of statute. The statute pertaining to cooperative societies are traced to entry 32, list 2 of Schedule 7 of the Constitution, which reads as follows. Incorporation, regulation, winding up of corporations and other societies, associations, cooperative societies. Now, Article 43B, which reads as follows. The state shall endeavor to promote voluntary formation, autonomous functioning, democratic control, and professional management of cooperative societies. Thus, voluntary formation, autonomous functioning, democratic control are essential features of the cooperative society, and therefore state in enacting a statute enabling the formation of a cooperative societies cannot under the guise of regulation violate any one of the above principles, inasmuch as right to form cooperative society guaranteed under Article 19(1)(c) essentially includes the elements, principles of voluntary formation, autonomous functioning, etc. as provided under Article 43B. There are decisions which say, in interpreting the rights, fundamental rights, there can be a guideline found in the directive principles. There are certain things which are allowed to be done for the purpose of governance. Importance is given to them as directive principle. Therefore, in understanding the fundamental right, they should also be read together. If that principle as held by the Supreme Court is to be imported, now the right of formation of a cooperative society includes a cooperative society of the kind which is voluntarily formed, which is autonomous in its functioning, which is democratically controlled, professional management, etc. All these facets, according to my submission, are included in that fundamental right. And definitely this 97th Amendment was in reply to take away the effect of Daman Singh case and that state of UP versus Chikoi case. It is for that reason this amendment has been brought about. Under the heading of regulation, there are provisions in all the cooperative legislation for supersession of the board of directors to appoint administrator. The supersession and appointment of administrator is an action directly affecting the democratic setup and the tenure of the elected body, etc. And therefore, the preconditions provided under the statute before passing the order of supersession are to be strictly complied with. It is held in the case of Sanjay Nagacha. Application of mind, speaking order, providing reasons. Non-application of mind, non-consideration of relevant material in respect of order or action leads to the interference that the said order or action is arbitrary and therefore violation of fundamental right under Article 14 of the Constitution. Passing an order at the behest of someone other than the competent authority is a good ground for judicial review, inasmuch as even if the order is passed on the direction or at the behest of higher or superior authority, still the said order is bad in law. For that there are another decision which I have given. Taking any action or passing of an order at the behest of non-statutory or at the instance of extraneous authorities or persons vitiates the order and a good ground for judicial review. Passing of an order in unholy hurry or to circumvent statutory provisions give rise to not only inference of arbitrariness, it will also give rise to the inference of legal malice. It is succinctly explained in the case of Fuljit Kaur. Malice in law. Legal malice is a very good ground for judicial review, provided relevant facts are pleaded so as to form a foundation for inference of legal malice can be drawn, as held in the judgment of Kala Bharati, Yashwant Bohar, etc. Alternate remedy. Like any other matter, in approaching the High Court under Article 226 and 227 of the Constitution, there will be a preliminary bar to overcome, that is, availability of the alternate remedy. The writ jurisdiction is not controlled by any conditions except those provided under the Constitution, but over a period of time, courts have laid down several self-regulatory measures and self-restraints such as availability of alternate remedy. Normally, all the statutes, including the relevant Cooperative Act, provide for appeal or revision. In the case of Whirlpool and others, the violation of principles of natural justice, the challenge to the jurisdiction of the concerned authority, challenge of validity of the concerned provisions are good grounds to invoke writ jurisdiction bypassing the alternate remedy. In fact, this aspect is dealt with very succinctly in the case of ABL International Limited, 2004 3 SCC 553. This is a judgment delivered by, three-judge bench judgment delivered by His Lordship Justice Santosh Hegde, where might be intentionally he traces it from 1952 and points out there are already judgments saying even in a disputed case of facts, if it is necessary to record oral evidence, there is no limit of any such restraint in writ jurisdiction, and it can be done under the writ jurisdiction provided the facts of the case require that. Arbitration clause, every one of the conditions of alternate remedy are dealt with. And one of the sentence used there is, in any case, wherever respondent opts to file a statement of objections, naturally he disputes. Therefore, it will not become a disputed question of fact. Disputed question of fact becomes only when the denial is not for sake of denial. The Supreme Court has held the fundamental rights involves all the facets which are enumerated in Part 4 of the Directive Principles of the State Policy. The state and its authorities interfere with the autonomy working of cooperative societies by issuing circulars, notifications under section, it should have been 30B, instead it is written as 13B. Under section 30B of the Act, such actions can be resisted on a better footing in view of the formation of cooperative society being made a fundamental right. This I have pointed out because In all the Cooperative Societies Act, there is a general provision, Section 30A, 30B, Maharashtra Act, in all the societies where government can issue the circulars if it is so required for the purpose of implementing the cooperative movement and implementing the provisions of the Act. That was being stretched to such limits. The Act which provides for reservation in favor of SC, ST, backward class, etc. in employment, in that a provision is made making it applicable to cooperative societies. That matter came up for consideration before the High Court. High Court said it's not for all cooperative societies. It can only be in respect of such of the cooperative societies where the state holds more than 50% of the this thing, or a functional control, total functional control is with the state. It is only in respect of such societies it will apply. Therefore, naturally what it follows is the reservation as provided under that Act is not applicable to the cooperative recruitment in Cooperative Societies Act. Immediately after that judgment, a circular is issued under Section 30B saying all the cooperative societies should follow the reservation pattern and the circulars issued under that Act. So in effect, that Act is given effect to by a circular to all the Cooperative Societies Act. Of course, those things came up before the court, they were struck down. But that is the tendency how something is sought to be done for the purpose of controlling. Now, with this being a 19(1)(c) formation being a right, there are several judgments in the matter of education institutions. Autonomy, what it is explained. In one of the case in Rajasthan, one matter, Supreme Court said, private unaided education institutions. Of course, you have all the power of regulation, but your power of regulation somewhere ends where it still remains a private unaided education society. There what was said was, at least the minimum that remains with the autonomy is making appointment to their institutions. You may say, for an education institution, these are the qualifications. Professor should be so and so, he should have a PhD, all these things. But you cannot appoint. Ultimately, it should be left to the institution to appoint. In our Act, what was done was, a provision was introduced as 128A of the Cooperative Societies Act, providing that in respect of all primary cooperative societies, here afterwards there will be a common cadre. It is the common cadre authority which will make the appointment, which will make the transfer, which will control all the aspects of those persons. Validity of that was challenged. Unfortunately, the division bench of our court upheld that validity. Even before this 19(1)(c) amendment, upheld that validity, saying it comes under regulation. Actually, even at that time also, it was not a case for upholding the validity. Then, after this 97th amendment, in 2013, that provision was deleted, thinking that it will affect the now with the constitutional setup. Again in 2023, that provision was reintroduced and was sought to be given effect to. It was challenged. It was challenged, and the learned single judge held that it is unconstitutional. It will not come under the regulation as provided under entry 32. It comes under, if it does not come under the regulatory powers, then it will have to satisfy the condition under Article 19(2), 2 and 4 with regard to the this thing. It is now struck down and the matter is pending in appeal. How the changes can have effect can be seen from that. Prior to 19(1)(c) amendment, a provision, section 128A, creating a common cadre authority to appoint, transfer, etc. of the secretary, chief executive of a cooperative society was enacted. After 97th constitutional amendment, 128A was deleted, but again by Act 27 of 23, section 128A is inserted. The validity of this provision was challenged and now it is struck down on the ground it affects the fundamental right. There will be such actions, circulars, notifications which may have to be challenged. A provision like 128A provides for section. This is one peculiarity of a Cooperative Societies Act is there are hierarchy of officials. Registrar, additional registrar, joint registrar, deputy registrar, assistant registrar, hierarchy of authorities, all of them are called registrar. And the entire act says all the actions are to be done by the registrar. It does not refer to assistant registrar or anybody. All actions, the power is vested in the registrar. Section 2 capital A, it is Maharashtra Act, UP Act, in all the acts that provision is there. It provides that the government may by a notification appoint any one of these hierarchy officers as confer them with the powers of the registrar to any one of these hierarchy of officers in respect of such class of societies. So notifications are always issued, making with regard to federal society or affect society, it will be additional registrar. District level, it will be joint registrar, like that. Whenever some action is to be challenged, one of the few things that we require to make a check is whether the person who has passed the order has been conferred with this power or not. A provision under section 2A provides for particular type of delegation of power. Such a provision is found in all the Cooperative Societies Act in all the states. By provision of section 2A(5), state government by a notification confers on any of the powers of the registrar on hierarchy of officers, that is assistant registrar, etc., and upwards. Many times the authorities passing the orders may not have been conferred with the power under 2A(5), which can be a good ground to challenge the order. With all this, it again brings us to the ground reality question is, it is in very few cases that you will be arguing about the fundamental right, etc. It is normal orders which are challenged, which you will have to make out a case to satisfy the court that this order is in contravention or this order is made to circumvent some provision to bring about an effect which is not permissible to be brought about. And unless you are able to put it to the court that somewhere this contravention is prejudices the party or it is brought about by misuse, etc., we will not be getting the relief. Judicial review, all said and done. Ultimately, with all these limitations, unless we make it a point to satisfy the court that a prejudice of such sort has happened, we will not be getting the relief. So with that, I conclude.
I'll proceed to the next item, presidential remarks. As you all know, Mr. Jayakumar Patil is a very senior advocate practicing in all branches of law. He is very thorough in all subjects, but especially with regard to matters of cooperation and this local board matters, Panchayat Raj, he is, I will not be wrong if I say, he is an authority on the subject. And his speech today has shown his knowledge of law, tracing from the very beginning. Virtually, he is tracing it from 1974 when he became a lawyer. So, on the subject, I do not think I can add anything to what he has said because he is an expert in the field. And the last case which he referred to, that is based on common cadre authority, though was upheld earlier by Justice Swami. After the Constitution amendment, Article 19 was amended along with 45P in Part 4. So, the learned judge, single judge has passed the provision for common cadre authority because of the amendment, and matter is pending in appeal before the division bench. So before concluding, I sincerely thank Mr. Jayakumar Patil. He has taken so much of trouble even to give a written brief on the question. I sincerely thank him for that. I also thank every one of you who have graced the occasion, and now I request as a token of our respect, Mr. Raghavendra will give a memento. Now the last item, vote of thanks by Raghavendra.
A very good evening to one and all. It was indeed a very pleasure moment. I sincerely thank today's speaker, Jayakumar Patil sir, for educating us various facets of cooperative law and its alignment with the basic structure theory. I sincerely thank once again, sir. I also thank our beloved president. He is the backbone for these particular programs. And I also thank DLN Rao sir for sponsoring this event. And a special thanks to Prasad sir for introducing today's guest. And I thank another special thank to Justice Nijiganavar for gracing the occasion. I also thank all the senior advocates present here, and special thanks to students and my brother colleagues. Thank you very much.